Hello, and thank you for joining us. While we wait for a few more people to join us and truly begin, I just wanted to welcome everybody here and go ahead and point out the chat feature at the bottom. If you'd like to familiarize yourself with the chat feature, go ahead and type the state you're from and maybe how the weather's outside so we can all find out who's got the best weather today. So we will give just a few minutes for people to join. In addition to the chat function in the bottom, there will also be a Q&A box. This will be where you'll be able to ask questions during our panel section, which will be the later half of the section. We will have our experts answer those questions. And if they can't today, get back to you with more information later. So again, if you're just joining, feel free to type what state you're joining from in the chat box and perhaps what weather it's like outside, so we all know who has the best weather today. Here in the lovely Castle Rock, just south of Denver, Colorado, it is a little overcast but sunny. And now that it looks like we have enough people in, I'm going to go ahead and get us started. So good afternoon, and thank you for joining us for today's National Conference of State Legislatures webinar, Innovations in Court Efficiencies Through the Lens of Consumer Debt Collection. My name is Michael Hartman, and I am a Policy Associate with NCSL, and I'll be your moderator for today. Before I introduce our speakers, I want to review a few housekeeping items for everyone. Today's webinar is a platform for information exchange and engagement. Use the Q&A box for questions for our speakers during our panel discussion, and use the chat feature to interact with all of your fellow peers. If you do experience any technical issues today, please write in the chat box, and our team will try our best to assist you. As a reminder, this webinar is being recorded. It will be published online approximately a week after today. Now that housekeeping is out of the way, let's get back to why we're here today. So latest reports show that total household debt in the United States reached over $15 trillion, while credit card balances increased by $52 billion. At the same time, the Consumer Price Index has risen 7.9% for the year ending in 2022, the largest since January 1982. Similarly, the Production Price Index saw a 10% increase for the year. And with rising prices often comes rising interest rates. Many of the most vulnerable in our communities will also be the most impacted by these increases in rates through variable interest agreements. As such, there is no better time than now to discuss our court system responses and what legislatures might be able to do to be a more innovative, efficient, effective, and equitable court system for all the parties involved. We will start with a brief presentation from one of our speakers, followed by a panel discussion where our experts will answer any and all of your questions that you might have. So joining us today is David Reed, General Counsel of Receivables Management Association International, Delegate Alfred C. Carr Jr., member of the Maryland House of Delegates, District 18, Erica Rickard, Project Director of Civil Legal System Modernization for the Pew Charitable Trust, and Heather Morton, our very own Senior Fellow here at the National Conference of State Legislatures. So first up, for our brief presentation portion, we have the wonderful Erica Rickard from the Pew Charitable Trust. Thank you so much for joining us today, Erica, and the floor is now yours.
Thank you very much, Michael. I'm really grateful to have a chance to be a part of this conversation. I want to start by just kind of setting some of the national landscape of what we understand is happening today when it comes to debt collection lawsuits, which are the vehicle through which consumer debt collection can happen in our court system. At the Pew Charitable Trust, the project that I work on focuses on civil courts. So what we started with was looking at doing some of the initial research to understand what are the leading drivers of civil court dockets. And what we found was that by and large, the dominant feature of today's civil court system is businesses suing individuals for money owed. So that's everything from mortgage foreclosures to landlord-tenant cases, by which we primarily mean evictions, to debt collection lawsuits. And debt collection lawsuits in this context, I mean really everything outside of the housing context. So that could be credit card debt, it could be medical debt, it could be auto loan debt or utility debt. And that's a feature that's really grown over the past few decades. So when looking backward in the 1990s, debt collection lawsuits represented roughly 1 out of every 9 civil court cases. And today, that number has continued to increase. In 2013, it was at 1 in 4. And that's the last year for which we have a national snapshot. But in more recent years, we were able to see consistently in states that make that data available that debt collection lawsuits are the single most common type of civil court case. So this is a significant trend. It's the leading driver of civil court dockets. And one of the other things that's really striking about debt collection lawsuits is how similar they look to one another. So I want to give you a little bit of a description of what happens in a typical debt collection case. So typically when we think about what happens in a court case at all, we think of a judge and perhaps a jury, attorneys on both sides of the case arguing the facts and receiving a ruling based on those facts. And that's not what a debt collection case looks like. But what a debt collection case looks like by and large is a judge or a magistrate, and on one side, an attorney representing a plaintiff or multiple plaintiffs, and on the other side, either a consumer representing themselves or most often an empty chair. And I'll talk about those 2 different possibilities in turn. So first, what we see is a real asymmetry when it comes to representation rates. Creditors, debt buyers, and debt collectors that bring debt collection lawsuits are most often represented by counsel if counsel's permitted based on the court rules. Where on the consumer side, in the jurisdictions that we've analyzed, fewer than 10% of consumers are represented by lawyers. One of the leading reasons for that, of course, is that consumers by and large, are not participating in debt collection lawsuits brought against them. So in the jurisdictions that we've been able to analyze, more than 70% of the time, debt collection lawsuits end in what's called a default judgment. What that means is that the plaintiff wins by default, not because of the merits of the case necessarily, but because the defendant fails to participate in the case. So that's kind of the backdrop of what debt collection lawsuits look like. And what I want to talk about next is what we're examining as kind of recent policy trends in changing how policymakers and courts handle debt collection. But first, just really briefly, one of the key questions that we've been asked before is, so this is an interesting facet of what's happening in our civil court system, but why does it matter to legislators? And I think there's a couple of key reasons. One is that this is a growing trend and it will continue to grow. As Michael said at the outset, we're seeing kind of increases in household debt. We're seeing increases in households reporting having civil legal issues, including consumer debt as one of those key issues. And that's really matched with an inconsistent patchwork of state policies around the country. And that even includes at the local level as well. The National Center for State Courts calls it a whack-a-mole approach to handling debt collection lawsuits, which can really lead to confusion and inconsistencies for creditors and consumers alike when they're examining how to handle these cases around the country. And then the last reason, perhaps the most important, is that while this is a real significant trend from the court perspective, it's an under-recognized factor when it comes to thinking about family balance sheets and how families are handling their wealth building or economic mobility. The role that the court-enforced debt collection plays when it comes to wage garnishment or asset seizure is something that is really under-recognized in this field. So these are some reasons why this is an important issue to be thinking about. And next, I want to talk about a couple of the key trends that we've been examining. Since roughly 2010, when the Federal Trade Commission put out a report about debt collection lawsuits, we've seen an increase in both courts taking different steps for how they handle debt collection lawsuits, but also state legislatures taking different steps in what state statutes look like when it comes to debt collection lawsuits. So the first that we've seen is changes to making sure that consumers actually know that they're being sued in the first place. One of the factors potentially for people not participating is failure to either receive court papers or recognize the name of the company suing them. So we're seeing some trends emerging in terms of states that are making their court documents more plain language, easier to understand, and also disclosing more information about the original source of a debt and the name of the company that that debt came from. The second change that we've been seeing is real clarification of processes. This is where state leaders and courts have an opportunity to recognize the fact that, by and large, consumers are coming at this issue without counsel, and these procedures and processes that have been in place to date kind of assumed that both sides would have counsel, right? So there's an opportunity here to take a step back and think about the process from the perspective of a person without a lawyer. You can see some of the user testing that's been done, particularly at the national level, to think about how do you give people information in a way that they can understand and act on. So we're seeing kind of simplification of forms, more white space, more plain language information being provided. So that's what's happening at the start of the case, in the beginning stages of a lawsuit. We're also seeing some changes when it comes to what the steps are before a judgment is issued against a consumer. So I'm showing here a map that has kind of a range of different states when it comes to what steps are required before a default judgment can come from a court. Some require a default judgment immediately when a defendant fails to respond to a lawsuit with an answer or fails to come to the courthouse. But we're also seeing some changes when it comes to documentation of the debt and review of that documentation before a default judgment is issued. And then after the judgment, there's even more court stuff that happens. So this is where there's additional policy changes that are being examined in counties and states across the country to think about what are the added court costs and other costs that are associated for both parties when it comes to post-judgment actions. So this is everything from garnishments that I described before, but also post-judgment interest rates and additional fees that can be associated with the court case. So there's a real range across the country when it comes to pre-judgment and post-judgment interest. And when states start to take efforts to think about what the consequences are of debt collection cases, we're seeing an emerging trend toward decreasing those post-judgment interest rates. And of the five things I wanted to flag, the fifth one is perhaps the simplest, and maybe should start at the outset, which is thinking about court data in the first place. What's actually happening in your community when it comes to debt collection lawsuits? Who is being sued, by whom, what is happening in those court cases? And it really does vary. But what we've seen is most states don't regularly report on debt collection lawsuits. And that's something that we're seeing start to improve. We're started to see about a dozen states now do report debt collection lawsuit information. Some of them have been reporting it over time. The more time that we have to be able to examine court trends, the more we can see changes in policies and whether those changes have resulted in any kind of real impact. That includes everything from the rates of filing to the rates of participation and what the outcomes might look like for all parties. I do want to highlight Texas as kind of the leading light when it comes to debt collection data right now. They're the only state in the country that provides a historical lens on all sorts of court cases, including debt collection cases, and all types of outcomes, including default judgment rates for all levels of the case, from small dollar to high dollar cases. So those are some of the trends that we're seeing. We do have a list of some of the promising practices that exist around the country. I'm happy to talk about any of them in more detail, but what I wanted to flag here was that the trends that we're seeing, even over the past couple of years, even just during the pandemic, really are starting to spread across the country, from all the way from Arizona to Maine. So this is something that's starting to be an emerging issue for states all around the country. Thanks so much for the opportunity to share, and I'll turn things back over to Mike.
Thank you, Erica. That was fascinating, and a lot of information that I didn't know. So next up, we will move into our panelist discussion. But before we get into that, I'd like to ask you all, attendees, a question following Erica's presentation. So if you'd like, and I'm not going to force you, but please put your answer in the chat for other attendees to read. But my question for you all is, what surprised you most about the debt collection court process that Erica explained? Or what surprised you, I guess, the least about that process? We'd really like to know your guys' thoughts. As you are typing your answer, I'll share what surprised me most. It's really surprising when Erica talks about the whack-a-mole approach in my mind that a lot of states have taken. For me, a whack-a-mole approach really isn't favorable for the defendant or the plaintiff. So it seems like maybe an area that some common ground could be found. So as you're typing in your own answers, I will give you a few more seconds before we begin our panel. We are fortunate in our panel to be joined by stakeholders from across the issue area, including national legislative experts, industry experts, and even on the ground legislative perspectives. So thank you all on the panel for being here and joining us today. I do have a few questions already, but don't forget, as attendees, you can also put your questions into the Q&A box, and I will try to ask the panel speakers those questions. As a reminder, this webinar is being recorded, and the recording and PowerPoint will be available on NCSL's website in approximately 1 week or so. And while some other people start asking questions in the Q&A, I'll go ahead and start kind of looking at Erica's presentation. I can't help but wonder to myself, what do you all feel is some of our, or are some of those contributing factors to the rise in debt claims more broadly? Is it just the economy right now?
Well, from my perspective, I think there's multiple factors that could be attributing to the increase in debt claims. To a certain degree, I'm not necessarily surprised by the increase, and to a certain degree, I'm not surprised it wasn't even actually higher. Keep in mind that the data set that was being looked at was 1993 and 2013. And within that 20-year span, the population of the United States grew by 60 million people. You also had a major change in federal bankruptcy laws in 2004, which made filing of bankruptcies a lot less appealing, which could potentially have been a cause and effect of increased litigation. Also, especially as you're looking at 2013, you're at the tail end of the Great Recession, which could have impacted the numbers as well. But also don't forget that there was an explosion in credit card issuance, issuing credit cards in the 1990s. So, that could have a role. And then finally, also the aging of the population. As the population of the United States gets older, there's more people that would take credit out. And, obviously you had the baby boom population and Generation X that was moving into an older age that would be taking credit cards. So I think it's actually all these types of factors combined that would explain for the increase.
We've also, oh, sorry, go ahead, Delegate Carr.
Oh, thank you, Erica. Yeah, let me just start by saying, thank you to all the participants who are watching. Thanks, Michael and Heather, the entire NCSL staff for putting this on, and my fellow panelists. Erica, you give me some great homework to work on here in Maryland. But a couple of observations I would have of, what is driving the current system that we have. I think one aspect, it might be sort of corporate consolidation. I just think of myself, I'm a dad, a husband, I have 3 young kids, so I am a frequent consumer of emergency room services at our local hospital. And so after our local hospital was acquired by a much larger company, some of their practices changed, and including they adopted the practice of suing people for medical debt over small amounts of medical debt. Even my wife got caught up in this. We had a little insurance dispute over our coverage that we were appealing, and we got a notice, my wife to appear in court for $75 that you owed for an ER visit. So I think that's one factor, and also possibly just kind of technology adoption and automation. Like in Maryland, we have transitioned all of our toll roads to cashless. That started in 2011, and that just completed last year. And when you do that, you can use Easy Pass, or if you don't have Easy Pass, that's fine. They'll take a photograph of your license plate, they'll look up the vehicle owner, and they'll send you in the mail, please pay your toll. And if you don't do that, you got to pay late fees and penalties. And so we're seeing people for, all sorts of reasons falling through the cracks and accumulating this, traffic debt and toll debt. And some of those cases ending up in court, and the same type of issues where, you fail to appear because you have to work. You can't sit around in a courtroom all day, then you're going to be on the hook for the entire amount. And I know during the pandemic, we had some of our courts in Maryland shift to Zoom, which was amazing. And we are trying to make that a more permanent thing, but it's going to take, I think, some time to get there, at least in Maryland.
Yeah, well, I've definitely had the experience of getting a nice toll road notice mailed to me as well. So I'm sure we've all been there. Several of us have, at least. And then Erica, did you have something you wanted to add on that as well?
Sure. I think both of the points that David and Delegate Carr were describing are right on. I think there's also, when we're thinking about the share of civil caseloads, there's also been changes when it comes to how personal injury and tort litigation has happened around the country. That might mean a decrease in those kinds of cases. But one thing that's interesting to note is that we did see over that same 1993 to 2013 timeframe, the overall civil caseload dropped by 20%. So within a drop of that, of the number of cases overall, even taking into account increases in population, we're seeing an increase in both the share and the total number of debt collection lawsuits. And that's actually a trend that we're continuing to see in the states where we do have data up to and including during the pandemic itself.
Well, thank you very much. And I promise I don't want to stick on the problems and identifying them too much, but I do have kind of a similar question along those lines. Coming from Erica's presentation, talking about kind of the role of consumers getting attorneys or not responding at all and not showing up. What do we think some of those factors playing a role there are?
Well, actually, I think the two slides in a way go together, because I think they're similar issues. But, you have to put yourself in the mindset of a consumer that owes a debt. Most consumers that owe a debt usually owe more than just one debt. So they're probably depressed. They're probably, a sense of hopelessness, and when they get a court order on a debt that they know they owe, I suspect many of them are like, well, what's the point? I'm going to go to court, take time off from work just to be told I owe a debt that I already know I owe. And so, I think that's part of it. And it's not to say that there aren't, issues that need to be addressed in court. I mean, there could be a situation that the wrong person was identified or the wrong amount was identified. And, obviously that needs to be addressed. But the fact of the matter is, I suspect a large portion of the people who don't show up to court is for that reason, which is unfortunate. I think, it really drives the question of what can we do as a society or as legislatures to make that court process easier for the consumer, less intimidating for the consumer. And I think there are opportunities there. Maybe a little outside the box thinking needs to take place. But I think, the reason why they don't hire attorneys for the same reason, again, they're in debt. In many cases, they know they owe the debt and they're like, well, why would I hire an attorney to go to court on a debt that I know I already owe? So I suspect that's partly in play, but I'm sure there are other explanations as well.
Well, that makes a lot of sense. Erica, Delegate Carr, does anyone else have thoughts on that?
There's certainly those are certainly some of the reasons that have been documented, reported by individual consumers and by court staff themselves. Other factors that we've seen include people not receiving court documentation, or whether it was properly delivered and they just didn't open it, or whether they opened it and didn't recognize the name of the company suing them, which is something that Maryland has sought to address. But also sometimes court documents themselves can look very, very similar to documents that don't look like they came from a court. So the kind of official imprimatur of the courts can get kind of lost when you're looking at documents that have been photocopied by other photocopies 4 times over, can look eerily similar to something that you maybe shouldn't take as seriously, right? So there's kind of some common sense operational changes that courts can make to make sure that the information that they're providing is taken seriously.
Yeah, and the only thing I really have to add is, when you get a notice from a court, it's scary for a consumer. It's a very official looking document, and just the language in it may be unfamiliar to you if you're not a lawyer. I know in Maryland, one of the issues was sort of the amounts. We had certain healthcare providers that set very low threshold amounts for suing people. If you're going to be sued over $75, you're certainly not going to get a lawyer for that. You're going to, either just ignore it, or you'll pay it or deal with it in another way. I think only people who would be sued for a much higher amount would even consider the idea of getting representation. But yeah, the medical debt issue was a real problem in Maryland. Even some healthcare providers, suing their own employees over medical debt.
And just one more point on this, I think one of the things that we've seen is actually when you increase the simple information that you're providing to people about a court case against them, you actually do see an increase in participation. So there was a study out of Boston that found that people who received simple information that included very basic steps about what they were supposed to do next participated at twice the rate of people who received the status quo of regular court documents.
I would agree with Erica on that, and that's I think that's sometimes runs counter purpose to sometimes legislation we see. Sometimes you give consumers too much. I mean, consumer notices are very important. You got to let the consumers know what to do next. But sometimes if you provide too much in the consumer notice, where it goes on multiple pages, the fact of the matter is, from what we can tell, consumers will not read all of those instructions and directions. They start to feel overwhelmed and shut down essentially. So I think it's important to find the right mix of how much information to provide in a very simple, straightforward way to a consumer, not to overwhelm them.
And I think that's an excellent point, and maybe some common ground that's just been found right now. Even there is trying to get this more understandable for the consumer who receives the notice, whether that means providing more information on one topic, or even tailoring it to make it more specific and kind of poignant, I suppose. But I would like to move along, and this question is actually tailored more for Delegate Carr. But kind of when you receive information from your constituents on consumer protection issues more broadly, what do these typically look like? Are they coming more from the consumers themselves going through the process, or stakeholders or other larger institutional groups as a whole?
Yeah, I think that's a really great question, Michael. And I do hear from consumers sometimes who, if they're savvy enough to know that there is a state legislator out there that they can contact through the email. In Maryland, we're relatively accessible. For those people who know that we exist, we're called delegates in Maryland, and some people don't know, aren't aware as aware of their state legislature and how to contact us. But that's one method. And when we do submit, when there is legislation on the topic of toll debt, we do find the stakeholders are very, very, very active on those topics, and they want to work with us to try to find solutions that work better. But we both have consumer groups that are trying to strengthen consumer protections, and we also have industry stakeholders who they feel like they provided services and they're owed money, and they're trying to figure out the best way that they can collect the money that they're owed.
Well, that makes sense, and it's nice to hear that you're actually hearing from both sides. I think that's the best way to end up with good policy at the end. And so, kind of jumping towards where we're going from here, just an overall question, and I'll actually open this one back up to everybody. What do you all see as key policy goals moving forward when it comes to consumer debt collection over the next few years, or kind of some of those milestones that we might be seeking to achieve?
I think looking forward, I know with the pandemic, I mean, it was pandemic has not been easy on anybody. But, sometimes you look at glass half full. I mean, we have learned some things during the pandemic, including how to embrace technology more for communication. 2.5 years ago, I didn't know what a Zoom was, and here I am on Zoom. So that development was definitely pushed forward because of necessity with the pandemic. And now that we all as a society seem to at least understand or embrace or at least be functional on these types of forms of communication, I think there's a real opportunity that we can leverage that within the legal system. Especially for a consumer who may not have time to take off of work. They don't have time to take a day off to go to the courthouse, or or maybe they're a stay-at-home mom and they have 3 kids and they don't have daycare, and they don't have time to leave their kids and go to court. I think opportunities like Zoom, if states were to embrace that as an opportunity to have live interaction between all the parties, including the judge and the plaintiff, the defendant, the attorneys, that could really be a game changer in helping to improve those statistics that Erica presented, where the 7 out of 10 don't appear. I mean, we may not be able to get it to 10 out of 10 appearing, but I have to think that we would get the number much better through technology.
Yeah, and thanks. Just to build on what David said, I think the great work that Pew has been doing, and Erica, I think they've outlined some best practices. We can see examples of some states that are doing a great job at either collecting the data or getting clear information to consumers so that they know what to do. So those can serve as models, I think, to Maryland and a lot of other states for things we can embrace to make this process work better. And I have to agree with David. I think technology is the way to go in some aspects. I'm not a lawyer, so I'm a layman when it comes to the legal profession. But as an outsider, my impression is that certain fields have not necessarily embraced technology, and the court system is one of those. In Maryland, I think they've been a little reluctant to embrace. In Maryland, we don't have. You can't bring a camera or a phone into a courtroom, and they were a little reluctant to embrace Zoom, and they did do that during the pandemic for certain types of hearings. And I think the legislature can help, to nudge them in the direction of embracing that where it makes sense. I think for some of the traffic and toll debt cases, they did get a much lower failure to appear rate than the in-person court dates that happened before.
So, and this is maybe a little bit of a self-plug from NCSL here, but we just released a state legislator news article kind of covering this topic about Texas's report on implementing a lot of remote and virtual hearings, depending on which state, and we call it different names, and how it did in Texas at least improve in their overall civil court process, improved participation, it seemed like, and that wasn't focused directly on debt collection cases at all, but it is perhaps good news towards growing our participation at least. But so we have, I think, had a few things that were more common ground based. Here's where we might get a little bit more anxious to put up some fights. But where do you all see kind of the larger tensions between stakeholders? So I know, Delegate Carr, you mentioned earlier you have consumer rights group stakeholders and sometimes industry stakeholders. And which sections or policy areas do you think there's the most tension to try to find that middle ground?
Yeah, I guess I'll start up and I'll just say that there's been quite a lot of tension in Maryland over medical debt, just because of I think the providers are seeing, a tremendous amount of medical debt. There are a lot of, issues in the healthcare field that we're trying to address and improve upon, but the, providers are providing services. They want to collect their money they're owed. Some of the systems for providing financial assistance are imperfect. We're trying to improve upon those. That it was, I think, pretty contentious in over the last several years in trying to find legislative solutions to make the medical debt system work better in Maryland.
If I may, I'll interject that, I've been tracking the legislation that's going around the states, and this, just for the 2022 legislative session, I'm tracking around 180 bills, and I would say around 50 of those bills are focused on medical debt issues, specifically on medical debt collection from various different ways. But it is very definitely is a topic that a lot of states are looking at.
Interesting to know. And before we jump too far outside of consumer debt here, I do want to pull us back in a little bit. And again, this question is perhaps more tailored to Delegate Carr. But as we all know, courts deal with a lot of these issues, and legislatures are then given the role of kind of oversight of their courts. So kind of more broadly speaking, where do you think the proper role for a legislature is when it comes to trying to make these court efficiencies? Is that being a guide for those who work in the courts, or is that passing legislation to be kind of a structural framework? And I'll leave it to you to answer that question.
Yeah, thank you, Michael. That's a really good question. And yeah, I think there's a healthy tension there between the legislative and executive branch. We do have a separation of powers. That's a concept that's important. And I think the courts like to sort of make their own rules in terms of how they operate. But I think there's a role for the legislature. We can sometimes force a conversation by introducing legislation. And we do have kind of an oversight role to, ask these questions of the courts as we, either talk about legislation or we make different inquiries. I think the legislature can be a nudge to push the court system in a certain direction, but just recognizing that they do want to have autonomy over how they operate.
That makes sense. And I would definitely expect pushback from the courts as, a lot of these processes are happening in their buildings. And I'm sure they feel very passionate about these issues as well, just like legislatures do. But kind of moving along here, we've spent a large portion of this webinar kind of focusing on the debt collection and consumer protections, but more broadly, how do these issues sort of intersect with some of the other legislative priorities that we're seeing? For example, you guys brought up medical debt, but even so, evictions or small claims or other realms. And I'll let anyone go ahead and answer that one.
I just, I guess, briefly talk about it a little bit from the small claims side. I know there is a trend, a small trend, but a trend nonetheless, to in the area of debt collection to pull debt collection cases out of small claims courts. And, and as an organization, RMAI struggles to understand the rationale for that. Small claims courts, essentially are the people's court. I mean, it's where you don't need an attorney. It's where you don't need to follow rules of evidence. It's where the consumer, quite frankly, in many cases gets the benefit of the doubt, versus a trial court where the consumer needs an attorney, where the consumer needs to follow rules of evidence, where there's a lot less flexibility. I do see that the small claims conversation comes up. We don't necessarily think it's in the best interest of consumers to not have access to small claims courts for that matter. And to a certain degree, we see actually when a consumer shows up to a case, they tend to be heard by the judge. So anyway, just a perspective there. But as for the other areas you talked about, evictions or family law, I don't think RMAI has any position on those.
I think that actually goes back to one of your questions earlier, Michael, about the kind of role that the legislature might have in things that show up in courts, right? So that's not limited to the kind of the oversight over court procedures, where I think Delegate Carr rightly points out the issues related to separation of powers, but substantively thinking about whether it's consumer protection or housing stability or other economic issues that are front and center for different legislative priorities, a lot of those things do play out in our court system. So we have seen, for example, an increase in the number of bills filed across the country that address evictions, how evictions happen, what the parameters are around evictions, and those play out in state and local courts. The same thing is true here when we're talking about whether it's medical debt or how debts play out in the court system. Those absolutely are fair substantive issues for legislatures to address, and in fact are the subject of many statutes. And we've also seen some changes to those statutes in recent years. So on the last point about the procedures, that we have also seen kind of friendly nudges coming from state legislatures toward courts to encourage more kind of user-friendly, plain language, simple processes to take place. Most recently in Texas, with kind of guidance toward post-judgment, clear, simple procedures for how consumers can say if they have exempt income or assets as a part of the end of a debt collection case. So that's something that was kind of a shared interest across different branches of government, started with a statute and is now playing out in a court rule. So there's a lot of overlap between these areas.
Michael, if I may, you had asked a question maybe 2 questions ago about what type of tensions between the stakeholders, and actually I didn't speak up because I was waiting to see if Erica was going to say something, but then you moved on. But I would just simply highlight that I think data and documents for many years was the area of tension. Do all the appropriate data and documents exist for a particular type of debt? And, if you go back to, prior to 2013, I think that's perhaps a legitimate point. But I think, given reforms, both at the state level through legislative, there's been a number of states, in fact, about 10, 11 states that have adopted specific boilerplate language. They all kind of look a lot alike, includes California, Oregon, Washington, Colorado, Minnesota, Maryland, New York, Connecticut, Illinois, and Maine. I think that direction has resolved a lot of the issues regarding data and documents, because it's forced debt collectors in particular to make sure that they get all the appropriate data and documents to prove up their case. And then, obviously RMAI has our national certification program, where we actually require more data and documents than even the states require on different asset classes. So I think the issue of data and documents is no longer a tension anymore, because it's readily available. I think the tension moving forward is more maybe in process, and specifically in the area like garnishment. I think that's an area of tension that exists between the industry and some of the advocates. What's the appropriate exemption level? Is $40,000 enough of income exemption, or should it be 60,000? Should it be 70,000? I mean, I think that's where the tension is moving forward. So I just wanted to throw that in there in the mix, so that that it wasn't glossed over. So,
and as the area of documentation that is perhaps no longer as contentious as it once was, still requires a lot of cleanup, right? David mentioned several states there, but not all states have consistent rules. So there might not be an area of tension so much as an area of some necessary legwork to ensure that that we have consistent policies across the country.
Yeah, I'd call it an opportunity. And, you know, obviously as an industry, you know, we're always looking for uniformity because, you know, many of the actors in this industry operate in all 50 states. And if we could take the best practice that I would argue has been adopted in those 10, 11 states and make it uniform across the country, it's going to make life a lot easier for everybody, both for the consumer as well as for the industry.
I'm actually really glad we've come almost full circle to this issue of whack-a-mole policies and looking for kind of that standard or best practice. We did have a question from Monique that was kind of curious about that specifically, and whether does anyone here foresee a federal enactment that might come down on the states enforcing a more uniformity? Or do we think that it's going to, for the most part, remain in the states' realms for the foreseeable future?
Well, I mean, you have obviously some federal consumer protection laws, the FDCPA, the TCPA, the FCRA. So, you know, I mean, they apply obviously nationwide. As for data and documents, you know, we haven't seen that at the federal level. In fact, we've actually, you know, approached a number of folks to see if there would be an interest. We see a potential value in having that as you know, a national standard. But you know, I mean, things in Washington move very slow. The states really are the incubators of ideas, and that's where things move a lot faster. So, you know, is it possible? Sure, it's possible. I don't necessarily, you know, I wouldn't hold my breath over it, I guess.
And even when we do see federal policy changes or federal regulations, the way that that's applied really does vary by state. So, for example, the CFPB's recent regulation F around the FDCPA includes something about prohibiting lawsuits being brought that are expired beyond the statute of limitations. How that plays out and how it's enforced within courts or at the state level really does vary.
All right, and to maybe leave us on a positive note, my final question is going to be like, what are some of those best strategies for consensus building that each of you have maybe come across through your experiences working in state legislatures?
So I guess I'll start off by, you know, saying I'm on the Health and Government Operations Committee, and I think we in the House of Delegates, I think we have a very good system in our committee of you know, operating in a way that we like to bring all the stakeholders together. We're inclusive, we're open, trying to find that common ground, and I think it's just kind of the hard work of having good communications, talking things through, and being open-minded and trying to find solutions. And I think my committee leadership and colleagues have done a very good job of that in Maryland.
I think one other area, in addition to that stakeholder engagement that Delegate Carr is describing, that's been really fruitful in states where we've been working is examining the local data. So we have these kind of common themes of best practices and ideal policies that have been kind of shared across industry and consumers across the country. But when it comes to what actually needs to happen in your community, the best way to understand that is to pull some docket data from your own court to be able to identify where the pain points are for plaintiffs, for defendants, for the court itself. And that's an area where Pew can help. If there are folks here who are thinking about where to begin, we're happy to help think through that with you, looking at what the national policy landscape looks like, how your state compares, and what your local court data can tell you about where there might need to be improvements.
Yeah, it's a great question, and you know, I think the answer to it is actually the same answer that I would suggest is the answer to a consumer debtor and a creditor, which is open lines of communication. I think the more that the industry or the creditors, originating creditors, debt collectors have interactions with consumer advocates like NCLC or Pew Foundation or whatever the various consumer advocacy, I have traditionally found, I do government affairs in all 50 states, is that the business community has perhaps much more in common with the consumer advocates than the consumer advocates may readily recognize or acknowledge. Certainly we do not want bad actors out there. I mean, bad actors, not only do they harm consumers, they also harm the legitimate businesses that are trying to do the right thing every single day. So, and I find that the more I'm able to have, conversations with people like Erica or with other advocates, we much more readily come to common ground. And I think, and the reason why I say the open lines of communication is also with creditors and debtors is, creditors they understand that they can't collect money if someone has a hardship, someone lost their job, they have a medical emergency, they have a death in the family, their spouse passed away. I mean, there's so many bad things that happen to good people every day. And, but the creditors don't know that's happening unless they're told that's happening. And the more that we have this open line of communication back and forth, the more that people can make accommodations or make concessions or compromises. And so I think the bottom line, no matter what topic we're talking about, the more communication that we have, the better outcome it is going to be for everybody.
Well, I think that's a perfect way to perhaps end our webinar today. So I would like to extend a final thank you to all of our presenters. We greatly appreciate your time and the expertise you each bring to the table and that you were able to provide here today. And thank you to our attendees as well for participating in today's webinar. As attendees, you will also all receive a sneak peek at an upcoming NCSL publication covering this topic itself in the next few weeks. And as a final reminder, a recording of today's webinar will also be posted on NCSL's website in approximately a week or so, and that will contain a link to the PowerPoint as well. So thank you all for being here today, and that is all we have.